In 1991, HHC created smaller layoff unit based on individual hospitals and healthcare facilities within HHC. In 2009, in response to financial pressure faced by the city, HHC again restructured its units. By memorandum dated 2009, HHC gave notice that it was amending its personnel rules and regulations to create 18 additional smaller layoff units within the existing hospital and medical centers that had previously been designated for layoff unit. Right? About 87 employees will be affected. HHC, line 28. HHC upheld the amendment asserting that the creation of layoff unit subdivision was within its line 2, page 2. It is page 2. It is line 20. It is well settled that judicial review of administrative determination is limited to whether the determination was affected by error of law, was arbitrary or capricious, or constituted an abuse of discretion. An action is arbitrary if it is without some basis in reason and it is generally taken without regards to facts. Line 26, where rational basis exists for an agency action, a court may not substitute its judgment for that of the agency, and the agency's determination acting pursuant to legal authority and within its area of expertise is entitled to deference. Line 32. And section 7.62, which governs the layoff unit, provided that HHC may designate an individual facility or division of any facility of HHC a separate layoff unit. Line 47. The agency did not act arbitrarily or capriciously by abolishing position and creating lower grade. A public employer may abolish civil service position for the purpose of economy or efficiency. And those sections on line 4. Those sections merely outline the order of layoff and the right of displacement within the same layoff unit and do not prohibit HHC from creating additional layoff unit. We hear this now, line 7. This is the court is saying here. The union made this case. The court is saying, although that it is unfortunate, in the absence of any non-conclusory showing of bad faith, we will not disturb HHC determination. And there is a thing down here that say they know that people will lose their jobs, senior people, but forget about it. It's in here. They're saying they know the impact of this, right? Will affect negatively senior people. The court said it, or wrote it in here, one of the sentences here, right? So against this background, this is where we are with this. And I can take the questions now. I have one final thing here. It's about, yeah, you can take this one. I'm just saying this part and then I shut up, okay? I just want you to get what's really going on. Members join unions. Look, when unions were being formed, two things people wanted: better working condition and job security. Work with me. When members joined union, it was to better working condition, pay and better working condition, right? And job security. Okay. So if we have a union contract, and we cannot speak to job security, the union contract is not of much use to the union, right? In the Constitution, they call it due process. This is not a constitutional question. We are interpreting the due process here. We are talking about the disciplinary rights, right, of workers. That if somebody alleges that they do something, they have right a certain procedure that they can have a hearing. Right? This is still America. Right. So the question we had was, you all know about Long Beach, and I'm not going to review Long Beach, right? But arising out of Long Beach, right? I'm not reviewing Long Beach, I'm just telling you where the reference is coming from. Arising out of Long Beach, the decision on Long Beach, again, the New York State Court said that the management can get rid of people, can get rid of provisional employees, provisional workers for 9 months or less. In fact, they should not have them for longer than 9 months. And therefore, all of the contracts that give people job protection after 9 months was not valid. Was not valid because there was a contract in Long Beach. The workers of the contract to say that they have a certain job protection because they were there a long time. Right. And it went up to the court. And the court said, forget it. Forget it. The contract must be subject to the law. And the civil service law says nobody should be there longer than 9 months in that thing. Right? So any contract you make guaranteeing benefit to workers is invalid. So all of the benefits that the workers have fell aside. One of the benefits the workers have, right? Provisional workers, right? Competitive title, right? Is that they would have disciplinary procedure. So that fell out too, right? So if the workers lost disciplinary rights, the union is going to fight for it. So the union fought for it. I'm just putting this in. The union fought for it and won it back for the agencies. Won it back for the New York City workers, right? DOH, MH, and all of these, right? Right? 1549, you know, these are the work. But HHC said, look, I am not going along with it. I'm not going along with it. So the union again fought it. And so the decision is here. That I'm just telling the decision. What's the decision? The union alleged that HHC violated New York City collective bargaining law. Right? Have you seen it on this paper here? Right? Yeah. And you see the citation is there. The union alleges that HHC violated New York City collective bargaining law, blah, 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 by refusing to bargain over disciplinary procedure for provisional employees. The union further alleged that HHC refusal to bargain constitute interference with the members' right under the collective bargaining law. HHC argued that it is prohibited from bargaining over this subject because to do so would require contravention of the law and violate public policy, and the prior decisional law and board precedent on the subject have been preempted by statute. So even though the rulings as always be, you have to bargain over this, they're saying the interpretation of statute, right, is that the members have no right. So even though the other city workers have this right, HHC is saying he does not have to do it. And guess what the finding is? The board found that HHC had no duty to bargain over disciplinary procedure for provisional employees and dismissed the petition. So all of these people that you see here, right, that are in these competitive titles in HHC, they no longer have all of these due process rights. I'm not saying HHC firing the people, work with me, but I'm saying all of these are powers that they have gathered, right? So the next step for HHC, for the union, is to force HHC to have exams.
Right. So
right? Force them to have exam. I say file the lawsuit in my name. But they say, look, this is the lawyer. Once you're filing this, you have to have the direct parties that are affected also signing off on it. Right? So we have to get all of these people in these titles, right, to sign certain documentation to say they want to be a party.